Hi, good morning, everyone, and welcome to another LinkedIn Live session with us by Prompt Personnel. Today, we are going to be covering the most overlooked yet high risk areas of compliance, workforce, contract labor management. Did you know that principal employers can be held legally liable if their contractors fail to comply with PF, ESI, or minimum wage laws? So, whether you're working with three vendors or 30, contract labor compliance is something that you cannot miss. And it is not an option anymore. It's a critical part of your business, right? From protecting yourself in terms of penalties, litigation, as well as reputational damage. So, in today's session, we are going to be taking a 360-degree view of compliance risk, of vendor risk, and we're going to cover everything that your contracts need to include, how you can track PF, ESIN contributions, how you need to conduct audits, how you can avoid misclassifications, traps. So, before we get started, here's a quick question. How many of you who are joining us here today have contractual workforce or have vendors with you who manage these contractual workforce? Please put your comments in the section as a yes. Let's keep this session extremely interactive and engaging for all of us. Yeah, so I'm your host for today. My name is Shanmitha Basakhetre, and I head marketing at Prompt. And I have a very exciting guest with us here today who's going to be hosting with me as well. Yashashree Kulkarni, General Manager at Prompt Personnel for Labor Law Compliance Division. Thank you so much for joining us here, Yashashree, today.
Thank you, Shanmitha, for inviting me.
Yeah. So just a very quick intro about Yashashree. I'd like to give her background. She comes with a rich experience of 18 years in labor law compliances, and she's worked with top brands like Kotak Mahindra and Edelweiss, helping them tackle complex compliance challenges. She's a veteran in this space, so I'm very glad that we have her with us here today. She's also a respected academic, having delivered lectures at the University of Mumbai's Law Academy, contributed to prominent legal journals. So we are so thrilled to have you here with us today, Yashashree. Thank you so much.
Thank you, Shanmitha. I'm also thrilled to be a part of this session.
Great. So just to set the context, now we are diving in, guys. I hope everyone's joined in and we are starting the session now. So to set the context, Yashashree, let's understand the historical backdrop of the Contract Labor Act. What were the key factors or challenges that have led to this enactment?
Yeah. So I think we all are aware India is a signatory to the UN and the Universal Declaration of Human Rights, which is the motherhood law for all the laws that emanate in our country as well as in signatory countries. Via this declaration in the Article 23, it has been mentioned that every single individual has a right to work, has a right to free choice for employment, has a right to have favorable and fair working conditions. So this right is a holistic right that it includes a protection against unfair treatment at work. It protects you against equal pay for equal work. So prevailing to this article, the Contract Labor Act in India has been equal. The Contract Labor Regulation and Abolition Act 1970 to be precise. So this act addresses the exploitation of contractual workmen and regulates the employment conditions. The aim of this act is to establish feasible conditions in pertaining to fair wages, decent working conditions, social security benefits for all the workforce, whether contractual or whether a permanent workforce. To further give a strong standing to this act, the Supreme Court, via the judgment of Shankar Mukherjee versus Union of India, has observed that the system of contract labor, particularly in the large companies as well as the PSUs in India, is still prevalent despite decades of independence. And the Supreme Court has expressed its stark disapproval to this system, calling it anarchic, primitive, and baneful, exploiting the workforce of bonded labor in India.
That's quite a backdrop, to get started with. So in most compliance documents, there are two terms that we come across, right? One is principal employer and the other is contracting. So could you help us understand what are these terms, what do they mean, and why are they so important under the CLR?
Sure. So the principal employer Society is an entity who has an ultimate control and is responsible for an establishment and engages through the contractual workman via a contractor. Despite the contract laborers being employed with the contractors, the principal employer is the one who holds significant legal obligations and legal liabilities under the Act, who is responsible for all the benefits that need to be protected, provided to the contractual workman.
Right. So a lot of times these, the lines are very blurred between the two, between principal employer and the contractual employer as well as the contract worker. So this is something that is a good starting point for us. Also, a lot of people think that, most business owners or organizations may think that contract workers aren't our responsibility. So, can you explain what kind of rights contract workers have under the Act? Why is it crucial for companies to take this seriously? How is it their responsibility?
Yeah, sure. So as far as the Contract Labor Act various provisions are concerned, timely payment, fair treatment, various social security benefit, welfare provisions, everything is the responsibility of the principal employer. By the welfare provisions, I mean providing canteen, good drinking water facilities, washing facilities, urinal facilities, yeah, insurances at places where there is a risky employment, PPE kits for workmen working on job roles in hazardous industries. Everything has to be provided by the principal employers. Just like the on-roll or the permanent workforce, it is the responsibility of the principal employer to ensure that the contractual workmen are also getting fair and timely wages. There is equal pay for equal work for contractual workforce as well. Just like the permanent workforce, there are the social security benefits like the Provident Fund and ESIC, the payments of which is solely the responsibility of the principal employer. Here, I don't mean that the contribution has to be made by the principal employer, but the principal employer has to ensure that while he's making the payment of management fees and the wages to the contractor, he also pays for their security, social security benefits.
Right.
He cannot run away from the liability of social security benefit. Also, he has to maintain certain records which establishes that the job roles of both the kinds of workforce is separate. Because as far as the act is concerned, the core activities mentioned in the section 10 or the perennial activities or which are very much crucial to the activity of the organization cannot be outsourced. There you have to have people who are the permanent workforce. But all the subsidiary, aligned, supporting job roles can always be outsourced. And the principal employer needs to make a clear distinction. He needs to keep records and registers, giving the details of both kind of activities.
Right.
In short, good governance of the contractual workforce is surely and 100% the responsibility of the principal employer and he cannot be absolved of.
Absolutely. So it is very much the responsibility of all the principal employers. You cannot run away from that. So let's bring this to a very important point that every business leader would want to know, right? From your experience, why is it that companies should treat vendor compliance as a business and reputational risk, not just a legal formality?
See, in the Indian parlance, if you are complying, if you are doing a good job, nobody will come and pat your back. But you will surely fall in the pit if you are non-compliant, if you fail somewhere. So the non-compliance under the social security benefits by the contractor calls for serious contraventions, serious repercussions that the principal employer may have to face. Under the PF and ESIC Act, there is an imprisonment from 3 months to 3 years that may be imposed on the principal employer. And after the non-compliances are detected under any of the provision, per day fine of rupees 1,000 is what the principal employer has to pay for such non-compliances. And see, imprisonment even for a single day is seriously shameful.
Absolutely.
No principal employer can bear that, block of being imprisoned for non-compliance. Just to share an anecdote, in a recent judgment, a renowned South Indian actress was given an imprisonment of 8 months. She was owning a theater in one of the renowned cities in the south, and she failed to make the ESIC and PF contributions in respect of contractual workmen. The court did not consider her weightage or her social status. She was given an imprisonment of 8 years. Of course, she must have appealed and come out of it.
Yeah.
She was made to pay a huge penalty amounting to nearly 52 lakhs in that case.
Oh my God. So the law, being on the wrong side of law, can have its repercussions no matter how big your personality is, or no matter where you are from, right? So here's another one on misclassification. How often do companies unintentionally, many a times it of course happens unintentionally, whereas there are certain companies who might do it intentionally, but the point is about misclassification of these workers, and what would be the risks if this happens?
Yeah. So see, I have seen that, in my experience, I've come across people who call contractual workmen consultants. Okay. They title them consultants. They make separate contracts with them and give them job roles which are quite similar to that of employees. Let us try to understand the difference between a consultant and a contractual employee. A consultant is generally engaged on a contractual basis to provide specific services or advice, and they retain a degree of independence while performing their tasks, unlike the employees who are subject to the employer's direct supervision and control. Consultants are not employees, and hence they do not receive social security benefits, paid leaves, health insurances, retirement benefits and all. As the relationship between both the parties is governed by a consultancy agreement. So many small companies make sham and bogus contracts, fraudulent contracts by representing the employees as consultant so as to evade social security benefits for them.
Okay.
But mind you, if these sham contracts are caught, then there is a huge risk that they will come across.
Okay. What kind of consequences, like in terms
Yeah,
of
so
sham?
there will be financial penalties. The courts may ask you to pay them backdated wages, backdated social security benefits, give them all kinds of superannuation benefits. They will also sue you under the provisions of the penal code or the Bharatiya Nyaya Sanhita. Set aside the contract, and civil as well as criminal prosecution will come into picture.
All right. Thank you for sharing that. I think it's very important to know that classifying workers or classifying your labor, contractual labor in the right manner is very critical, because this can also be construed as being non-compliant. So now talking about a little bit more about hiring contractual employees. This is being looked upon more so as a strategic decision in various segments and various sectors, such as e-com or quick com, even retail, where they require that kind of flexibility, where seasonal hiring is something that they look for. So, can you explain how these sectors are using contract labor effectively and how it makes sense for their business models?
Yeah. So primarily, there are 5 primary aims of contract labor: reduction of costs, having better access to specialized skill, increasing flexibility in the matters of hiring and firing, outsourcing of non-core activities so that the focus can be on the core competencies, improve the efficiency, and get a competitive edge or advantage in the working conditions. Now, there are many industries in our country which, boom in specific seasons, like the e-commerce industries, retail sector will be on a boom at the time of festivals. And after the rainy season, when the harvesting season is there, the agriculture sector will be at its boom. Tourism sector will be at its boom in the vacation time. If you look at industries, we have a lot of seasonal industries in our country. To give you a classic example, sugarcane industry in Maharashtra is the booming industry. It rules the state of Maharashtra. But this industry works only 110 days in a year. You do not have the sugarcane industry working round the clock across the year. Only 110 days the manufacturing or the production process takes place. So it does not make business sense for any of the owners to have the workmen employed across the year. Primarily, these workmen are migrant workmen coming from various states in India, coming from drought prone areas to find some work. And you cannot have them employed across the year. They are to be employed only for that specific period of production. So it is here the contractor's role comes into picture to identify them, recruits them, gives them the right platform, and then the principal employers can employ them, use them to their best benefit. Thus, he can save a lot of his headache, in the terms of hiring, firing, their cost, their stay upkeep, etc., etc.
So if you were to tell the our HR audience who's tuned in today as to how they should consider or for hiring for contractual staff, what would you say for that in just one line to summarize for this?
Yeah, so cost efficiency, access to more specific skills, like if there is some IT outsourcing and you outsource this to an IT sector company, or if you want more flexibility of not carrying the baggage of lot of workmen at all times when there is a downtime at work or when there is not much work. Will all and contractual workers will always give you an added advantage to focus on your core competency. And and the contractor is always there to manage your risk of having this additional workforce. So in all these sectors, e-commerce, retail, agriculture-based industries, tourism industry, contractual workforce hiring is the best.
Lovely. So, guys, please let us know in the comments as to whether you have contractual workers or you have vendors that you're managing and which sector that you are currently tuning in from. So, coming back to the compliance angle, Yashashree, in terms of state level differences. Now, we understand that there is not one law which governs, in every state, and every state has its own rules, its own thresholds. Can you explain why is it that it varies and what is it that companies need to watch out for, especially those companies, those brands who would have multi-location presence, so different states, different compliances. Is that true?
Yeah. See, Contract Labor Act is a motherhood act made by the central government. For that matter of fact, all labor laws are made by the central government and the rules differ from state to state. So between the central and the state level, there is a division of legislative and administrative responsibilities for more better functioning of the government. Yeah, so Contract Labor Act is a central legislation. It comes under the concurrent subject as mentioned by the Constitution of India. And in the various jurisdictions, there are different authorities who are responsible for the implementations of the provision. So though the basic provisions as to the responsibilities, duties of the employers, employee, a what is a core business, what is a non-core activity, all these things are mentioned in the Principal Act. But the administrative part as to where do you go and obtain a contract labor registration certificate? How many people, what is the threshold of obtaining a license? Where is the fees of security deposit to be made? Which is the competent authority in a particular state and a city? All these things, this information will come to you via the rules set up by the specific state government. And these state government rules are very specific to the unemployment ratio,
Right.
or to the inflation ratio in that particular state. Like in the state of Maharashtra, up to 50 contractual employees, you are absolved for any kind from any kind of compliances. But there are smaller states like a Kerala or an Andhra Pradesh, even if you hire five contractual workmen, you are liable to do each and every compliances. Again, it is very state specific depending upon multiple factors of that state. So one organization who has multi-locational presence, a multi-state presence, should always look at these state level dynamics if you are pondering or you are jumping into hiring of your contractual work, of course.
That's quite an important point actually, because if companies have multi-location presence, then it's very complex for them to keep track of so many compliances across India, across where they are present. So I'm sure an expert like you can definitely advise them in such scenarios on what kind of compliances to take care of. Moving on to vendor contracts, as this is one of the aspect of our today's LinkedIn Live, what are those must-haves from a compliance perspective that every vendor contract should include?
Yeah, so like any other contractual relationship between two parties, a well drafted agreement is the crux, is the baseline of the relationship. So, for any successful collaboration between any service provider or between two parties, the most important is how well drafted contract, how well drafted you have your expectations setting between both the parties. So as far as the contract labor agreements or the outsourcing agreements are concerned, I think the primary things which you should focus on or a company should focus on is how the compliance obligations will be taken care of. Whether the contractor is confident enough to see that the timely compliances are being handled. Whether there is a risk assessment and risk mitigation done by both the parties on a timely basis when they are entering into the contractual agreement. What is the dispute resolution mechanism? See, most of the relationships are prone to disputes at some point or the other. And we should always ensure that in any such contract between a contract labor management, we have the clauses related to arbitration, negotiation, mediation rather than running to the courts because the litigation in India takes years together and it's fruitless persuading it. Then comes the part of indemnity. See, as I have been mentioning consistently, the principal employer has a huge role, has a huge liability. So while the contracts are being made with the outsourced companies, with the contractor, you have some provision to indemnify yourself if the contractor fails to make the payment of its statutory dues. You ensure that you have some bank guarantee or some amount kept with you as an indemnity, protect you from non-compliance. Then last but not the least, the background checks and due diligences. Please ensure that the contractors that you are hiring, they are known contractors, they have a good repute in the market. Please conduct a thorough due diligence as far as their various registrations like PN, PSIC, PT, Labor Welfare Fund, or any other state specific registrations are done by them. And please have a contingency planning clause that tomorrow if the relationship between both the parties fails, how are you going to take care of the compliances? And that will surely protect the companies from any kind of fallouts or risks.
Thank you so much for giving those insights. So, all of y'all, in case if y'all are still unsure whether your vendor contracts are compliant or not, drop a yes in the comments. You can reach out to us and we will get back to you with the solutions. Moving on to tracking PF ESI contributions to avoid vicarious liability. Now, we've heard a lot about this concept called vicarious liability. Can you explain what it means for the principal employer?
Yeah. So vicarious liability is a term in the torts law, Indian torts law. Yeah. Vicarious liability means one person is held responsible for the actions of the another person, even if he has directly not committed the wrongful act. Yeah. This typically arises from relationship between employers and employees, where the employees are carrying on acts under the direct supervision and control of some representative of the employer or the management. And in the contract labor arrangement, it is the principal employer who is vicariously liable when he is managing the contractual workforce. So any fallouts by the contractor, it is primarily the principal employer who will be liable, like non-payment of statutory obligation. Though the primary responsibility stands with the contractor, yet the principal employer is not absolved. Default of salary payments by the contractor, though the primary responsibility is that of the contractor, yet the principal employer is not absolved. Taking care of the workforce, protecting the workforce in hazardous employment in factories, in mines, yeah,
Principal employer
yeah,
needs to take
any
care.
other risky situation, it's the principal employer who has to take care. And this is how the principal employer is vicariously liable for all the acts that he is doing in respect to the contractual workmen.
It's like a 360-degree view that the principal employer must have because a lot of liability, like you rightly said, rests on the principal employer, even though the contractor is in place, right? So, I feel like you have a lot of stories to share, Yashashree, about this. Are there any landmark cases that you would want to tell us on this aspect?
Yeah, so in the Indian context, our Indian courts or the Indian judiciary has been always pro workmen because of our social security, scenarios. But there are very few such judgments or instances where the courts have come to the rescue of the principal employers or to the employers or big
Employees.
organizations. And I would like to throw light on one such case, that is Bharat Heavy Electricals Limited versus Maheshwar Prasad. This is a case reported in the year 2019 where the Supreme Court has reversed the judgments of the labor courts as well as the High Court when 64 workmen went to the Supreme Court claiming permanency, saying that they were entitled to all the rights of the permanent workforce. So the Supreme Court said that in absence of a robust documentation, in absence of a notification that reverses their current employment status, they cannot be considered as permanent workforce. So the key takeaways of this judgment that I would like to share away with all our viewers, that whenever you are hiring contractual workforce, maintain clear records of what is the work that is being carried on by the contractual workmen. Please have clear agreements in place, payment records in place, role assignment, details of role assignment in place. So, in huge manufacturing units, there may be instances where the contractual employers as well as the permanent workforce both are being given identity cards, gate passes, they are having accesses to all the places in the premises. They are also having similar uniform. But that doesn't mean that the contractual workmen become the permanent workmen and are entitled to the similar kinds of benefits or to the permanency and cannot be removed or cannot be done away with when their job roles are over. The agreements, the payment records, the relationship between the two parties plays a very important role. Periodic audits should be done of the contractual workmen and the duties carried on by them. Evidentiary support of all these things comes handy in such situations to all the principal employers in case of disputes.
That's quite nice to know. And the fact that the law will support principal employers if they are on the right side, if they are following all the compliances, there is nothing to worry. So while this really sounds tricky, I'm sure these landmark cases are an example that principal employers can be protected if they are compliant and they follow the right norms. So I'm sure with this example that you have given or landmark case, a lot of people would have that fear. And even today, employers have that fear that what if my contract is claim permanency? Can they do that in the first place?
Yes, so there have been a lot of instances in the past when the contractual workmen have tried to claim permanency, citing reasons that they have been engaged in non-core activities, or they are being there for a long time. Though they are on contractual work, contractual arrangement, it has been so long that now they are entitled to all the permanency benefits. So here I would like to cite an recent judgment, Kirloskar Brothers Limited versus Ramachandran, again a Supreme Court judgment from the year December 2022, where the Supreme Court has categorically mentioned that there is no automatic absorption of the contractual workmen under the Contract Labor Act. Okay. So in this particular case, there were a few workmen that the Kirloskar brothers terminated, and the industrial tribunal ordered the reinstatement and absorption of these contractual workmen in the permanent workforce. But Supreme Court has overturned this decision, saying that automatic absorption cannot be there. So again, the key takeaways of these of this judgment I would like to share with it. Please streamline your vendor management. Please again keep all your compliances under one roof. If you want to do away with contractual workforce, please have a proper paperwork and make it clear by various letters issued to them that this job role is not a core job role and they have been assigned this job role for a specific period and specific purpose only. This is these two judgments. If they are thoroughly studied by all our viewers, I'm sure nothing, they will not have any pitfalls in this arrangement.
No, definitely we'll share these two landmark cases with our audience who's tuned in today. It would be very insightful for them to apply the same sort of learnings to their organization as well. You mentioned something about core and non-core even earlier. A little bit more on that, please. What is core, non-core, and how to?
Core activities is something which is the bread and butter of the organization. Now, if I have to give you an example of a bank, in a banking, managing cash transactions, yeah, treasury management, managing the money will be a core activity. So it cannot be outsourced. But bookkeeping, record keeping, cleaning, security services, this paper pushing, documentation, keeping the documents, back office activities, all these activities can be outsourced because the core activity of a bank is managing your money. You giving you more interest. The grossing of the profits of the bank, not managing papers, not keeping upkeep and housekeeping of the branch. So the whole activity cannot be outsourced. A treasury department cannot be outsourced. But yes, an HR department, an admin department, a back office department can always be outsourced.
Thank you so much for that. And I want to quickly summarize, before we move into the Q&A session, I want to summarize a lot of key takeaways that we've learned today. Number one being that, of course, contract labor compliance is a non-negotiable. Principal employers are equally legally liable if their vendors fail to comply on PF, ESI, wages, or welfare provisions. Vendor contracts need to be, second number is vendor contracts need to be airtight, watertight. Uh, Clear clauses on compliances, audits, everything that we mentioned earlier, dispute resolution, indemnity, make sure that these clauses are very, very airtight to protect you from future risks. Third, we spoke about vicarious liability. It is real. If vendors default, your company pays. So make sure that you are protected both financially as well as reputationally, which is also a higher risk for you. Fourth, audit your vendors regularly. Like ma'am mentioned that it's important to set up a structured risk-based audit process to monitor your vendors on a frequently, timely basis, be it quarterly, annually, and more so proactively. Fifth, avoid misclassification traps. Now, like you very rightly mentioned, mislabeling them as consultants or freelancers is not okay. It can backfire with litigation as well as penalties. And lastly, staying updated with state-specific laws, labor law thresholds and rules vary across states, and ignorance is not a defense. So all of this is quite important. And if your business is already working with or is employing contractual workers, you're planning to, or otherwise, staying on top of compliance is very key to unnecessarily avoid these kind of risks and compliances penalties down the line. And you can stay in touch with us over business at promptpersonal.com, and we will share these details on the comment section. Now we'll quickly move into the Q&A. I'm excited to know what our viewers have put in today as questions. So let's take on one by one. So to start off with, what documentation is critical for HR teams to maintain to avoid liability during inspections? Vaishali asks this question.
Yeah, so whenever there is an inspection under the Contract Labor Act, it is at most important to ensure that the wages registers, the pay slips, the PF and ESIC payment records are in place. The wage slips and the muster rolls, you should ensure that the salaries are at par with the minimum wages. The moment there is a deviation in any of this, then surely there is a pitfall for the principal employer.
All right. Let's look at the next one. What are the legal risks if contract workers are mistakenly treated as employees? Ankur Gupta asks this.
So if contractual employees are by mistake treated as on-roll employees, as I mentioned, they may claim permanency. They will be eligible for all the benefits that a permanent employee has. He will also be entitled to all the retirement benefits like gratuity, superannuation, pension fund, etc. So always ensure your documentation in respect of the contractual employees is clear, clean.
Okay. Another one by Mr. Ajay Kakkar. How can small and mid-sized companies manage vendor compliance without a large legal team?
So without a large legal team, it is very easy to manage the contractual employees. You have to ensure that the way I explained you have to make a good contractual document. One time, take support of some expert or some, external legal consultant, replicate the document any number of times that you are going into a contractual arrangement. And please stay tuned on various news channels or on legal updates on various websites as far as the changes in respect of the contractual laws are concerned. Any state specific ruling, any state specific notification, if you yourself keep a track of that, you will surely be absolved from any unnecessary liabilities.
So this is somewhere where I'm sure you can support such companies like
Sure.
wherein they don't have a large legal team and you can provide consulting advisory as well as conduct audits. That's what we do at Prom Personal. So you can definitely reach out to us, Ajay. Um, just a couple of more questions I would like to spend some time on because our audience has asked quite a lot of them, I can see. How can HR ensure there's no overlap between contract labor roles and core functions?
So as I explained some time ago, what is a core function? A core function is something which is the heart of the business, like replicating money, getting interest in a bank. Similarly, if you look at a theater, selling tickets is the only core function, so that cannot be outsourced. Some activities like cleaning,
Right.
housekeeping, selling popcorns can be outsourced. So something which is the basis
Base.
of the industry is a core function and something which supports the activity is a non-core.
So base versus support functions. Let's keep that in mind. Yeah. Can you explain the concept of contract of service and contract for service? How to ensure vendor compliance when the work is offered like renovation of offices? This is by Mr. Prashant Kag, General Manager at Reliance Hospitals.
Okay, so contract for service and contract of service. So contract for service is typically an outsourcing job that you give it to someone else who comes on your premises for some time in a day and leaves. Renovation of an office, carpentry work, any BMC, that is the building maintenance kind of service. There you do not have workforce which is seated on your office throughout the day. He will come for some time and he will leave. You may have an agency, permanent agency who will support you in such activities. So we had landline phones long ago, which
Yeah.
would always, stop functioning midway. And we always had to get in touch with some vendors who would come and, repair them. So we couldn't have a telephone repairing guy permanently seated in our office. But we always had to have an agency handy who will send somebody to repair it. We have huge washrooms in the office and top on and off the there is some plumbing issue. You cannot have a plumber seated in your office for that. But yes, you need to have some agency with whom you have a contract who will support you with the plumber whenever there is an issue. So this is a contract of services and contract for services.
For
Contract of services, you need a data entry operator, but you do not want to hire it. So you have to have agencies in place who will give you any number of data entry operators as and when you require. So this is the difference between the two kinds of contracts.
Thank you for asking this question. It was quite an interesting one. Another one. What are the red flags to look for when selecting a manpower vendor? Vidhi Verma asks this question.
Yeah. So as I had mentioned, please do a proper due diligence of the contractors. Today in the market, there are a lot of Tom, Dick and Harry kind of contractors. Any person just comes and says, okay, I'll supply you manpower and I'll get your work done. But in absence of the credentials of such a contractor who is not complying to PF, not complying to ASIC, not making the payment of the minimum wages, it is always risky. It's always risky for the principal employers to carry on compliances. So always these are red flags, whether he's renowned, whether he's having his own office, whether he's compliant to PF, ESIC, these are the red flags. Check his past history. Ask him for his login credentials and check whether he's been making timely payments. If you're
Right.
doing that, surely you will protect your organization.
All right. Deepa Pillai asks us what training and education programs should we provide to employees and managers on labor compliance?
Okay, so training programs, so you have a lot of short term, courses on labor laws, various organizations, or even we at our learning and development vertical provided. And anybody who is a labor, in the HR department, I think contract labor at PF, ESIC, minimum wages are some bare minimum things they should have an exposure to either by self-learning or via learning and development tools.
All right, all right. Uh, Another one from Mr. Prashant again. Even though the principal employer has settled all dues to the contractor and he fails to pay those dues to his workers, how principal employer should ensure the compliance?
So when you're making these payments, please have your, bills or your invoices, bank transactions clear, because this is what is the supporting, evidentially support that you will have to give to the courts of law. The courts may ask you, why didn't you conduct periodic audits? So as I have been saying that, please ensure that the audits are regular audits, because again, not having a periodic audit is a pitfall for you, and documentary absence of documentary support of having made timely payments to him also is a risk factor. So documentary support and timely audits is what you need to ensure.
Audits and documentary sir, evidence. Okay. And usually, so this is a long one. Usually there is a lag in enrollment of CL for PF and ESIC due to EPFO and ESIC organizations requiring KYC, which many CL do not have. As a result, contractor enrolls them without PF ESIC deduction. Is it permissible or too risky, and what is the remedy for this? It's quite a lengthy one.
See, so as the government, various departments have been enforcing that you always hire people who are having Aadhaar card. I think the only KYC which is mandatory for PF, UN creation, or a temporary identification number creation is the Aadhaar card. If the Aadhaar card is in place, then none of the enrollment process will, take time. Immediate action may not come in picture, but the pitfall is in case there is an accident, if in case the person is doing a job role which is hazardous, he is a loader, picker, packer, he's working in a hazardous industry, and unfortunately he meets a small or a big accident, then your pitfall comes. See, anything which is undetected is not a crime, but if you are having a bad luck and it is detected, then it is a pitfall, not then.
Okay. Another one, another one on the contracts part. What are all the mandatory points that we should cover in a contract if we want to make a short agreement? But we've already covered this.
Yeah, we have already covered this.
Just, I think what she wants to ask here is, what if you want to make a shorter agreement? What kind of mandatory points that we need to cover?
See, compliances, risk mitigation, compliances, and audits. So audit and compliance are 2 points which you should not play with and you should have.
All right. Just a couple of few questions, Yashashree. Should we have different compliance frameworks for manpower contract employees and service contract employees?
Yes,
By
you should. Yes, you should.
We should.
Yes.
All right. Another one. What are the differences in compliance expectations between states? We've already covered this, but how do we track this effectively?
So track this effectively. There are a lot of legal websites, or you can follow us on our Compliance 360 page where we have put up a table in with each state. What are the compliances that we need to follow? It will give you a proper eagle eye view of each of the states.
We will share the details. You can subscribe to our newsletters. We on a weekly basis we share state-wise compliances and what you need to basically follow, and even a monthly newsletter. So you can subscribe on our website and we can definitely share these details for free, Sona. Any other questions? I think we've come to the end of our session now. Anything else? All right. I think we've covered quite a lot and it's been an extremely insightful session. I would really like to thank you, Yashashree ma'am, for being with us today, for contributing so well onto this topic. I'm sure everyone found this very insightful. Please do follow us on all of our social media handles and we will share those links in the comment section and you can directly reach out and to even Yashashree ma'am through our email address, and we will make sure that your queries are resolved. Also, stay tuned. In the first week of August, we will be coming back with another very interesting and hot topic, which is on the ELI scale. And this is something that is still in the pipeline. And in the first week of August, we'll be there. So thank you so much. I really appreciate all of you all joining in today for this LinkedIn event. Thank you.
Thank you.
Ended.